Interesting conversation with the new chief deputy there with the Advocacy Center here in Oneida County, Rick O'Mara, and talking a little bit about what they do, the programs and the services they provide to those victims here in and around Oneida County. We're going to get into it. Mark, throw your headphones on. I know you like this guest. She's joined us in the past. Emily Taylor. She is a Second Amendment expert. She is a former prosecutor, and she is from U.S. Law Shield. We're going to talk a little bit about, you just heard Jolene talking about the Remington suit, and they will ask the U.S. Supreme Court to hear its appeal of the Connecticut court ruling that would reinstate a wrongful death lawsuit against the company, and they're being targeted over the way that they marketed their rifle that was used in the Sandy Hook Elementary School shooting. Emily joined us in the past, and I think most notably when we talked after the Las Vegas massacre, and she made us aware of the bump stock device or mechanism, which is now being outlawed throughout many different states. Emily, good morning. Thanks for joining us again.
Oh, good morning. I'm happy to be here.
We appreciate it. And not only on a local level, and I'm not sure how much or how aware you are, but Remington, their Ilion plant is just a stone throw away from us, and our studio here, not that far away. They are our neighbors in Herkimer County. We are in Oneida County, so we know that there are a lot of folks that are employed there, and we know what that means to the Ilion community and the Valley. But here we are, the story picking up some national attention as well. And as you just heard, our local news report, as I mentioned, Remington Arms going back to the U.S. Supreme Court. And I know you've been following this. So how do you feel, or how do you think this is going to play out? I know this has been equated or likened to what the cigarette manufacturing and the cigarette lawsuit brought to their industry, and how this might equate or look similar. But your thoughts going forward on this? What do you think?
Yeah, well, I think it's important to understand exactly what happened, because there are probably a lot of people out there who are saying, I thought that gun manufacturers couldn't be sued.
Right.
And that's actually the law, is that, and it makes perfect sense when you think about it. I mean, it causes some level of outrage amongst the gun control community, but when you manufacture a firearm, every firearm is capable of causing the death of a person. That's what they're for, right? I mean, they're deadly weapons. And so what we say is you can't bring a lawsuit against a gun manufacturer every time a firearm is used for its intended purpose. You would put them all out of business.
So, and that was some protection put in place, I think, 2005 to protect those gun law.
We should just point out that's a federal statute, right. So that should apply to all 50 states.
Exactly, and that was a bipartisan law, because people want to protect, jobs that employ Americans, and just like y'all were talking about earlier. And so, what we have in this lawsuit is, plaintiffs, and of course, I have complete sympathy for these plaintiffs, because I have no idea what it would be like to lose a child in a mass shooting. It's got to be just awful, and I know that they're looking for, some level of justice here. But what they've done is convince a judge that the lawsuit should not be based necessarily on the fact that Remington made a gun that killed someone, but instead that Remington marketed the firearm in a way that was, I guess, inducing young men to commit these sorts of horrible acts, which is, I think, absolutely ridiculous on a lot of levels. The most obvious being that the Sandy Hook killer didn't buy this gun; his mother did. So there's no what we call proximate cause in the language of the law. So it's a very odd ruling by this judge.
Mm-hmm. Is this one judge, or is this when it says the state Supreme Court ruled that they can be sued, is that the highest appellate court in their state, or is that a single judge that made that ruling? It's not clear to us.
That's out of Connecticut, right?
Yes, out of Connecticut. Can you clarify that for us?
Oh gosh, I wish I could. So I'm a Texas lawyer. In Texas, what we call the state Supreme Court is actually the highest court. In lots of states, what they call the Supreme Court is actually going to be the lowest court. And
that's
I'm not
the way it is in New York. The same.
Exactly.
It's a trial court.
I'm not sure which way it runs in Connecticut. What I do know is there is going to be a long appellate process, but it's got to start with, now that we're back at this point, it's got to start with a jury verdict. And that's what the plaintiffs are counting on, right, is that they're going to find jurors' sympathy, even though the legal mechanism here doesn't make a lot of sense. You're going to have 12 people who are just like us. They're just people, and they're going to hear horrific stories of young lives, children who are dead. And, what I think what they're counting on here is not that the jury looks at the law, but that they rule based on emotion, at which point, it could take years and potentially up to the U.S. Supreme Court to deal with whether or not this is an appropriate legal mechanism.
Sure, and Emily, as you pointed out, we have sympathy, and I think we all want justice, and none of us want to even be talking about these stories. But I think that this could be a precedent when you're looking at this case. Kind of going back to what I mentioned, and I know there was a story linked to me booking you, which had to do with the lawsuits against the cigarette manufacturers. So is it a slippery slope, I think, is part of the question as well. But can we go, and I don't know if we have a better understanding or the best understanding about the specifics. What is Remington specifically being targeted for? What portion or part of their advertisement, I guess, are they being scrutinized about?
Well, and this is what makes it like the cigarette manufacturers, is that essentially the argument is they knew when they marketed this gun that they were essentially encouraging young men to shoot people to validate their masculinity. And so, like the cigarette lawsuits, what the plaintiffs are going to be able to go in and do is look at internal communications, internal emails, all of the, anyone who has ever worked in a company with the marketing department, that there's lots of conversations about how are we going to get people to buy more of this product? What are we going to say? How is it going to look? And so what they're hoping to find are, a la tobacco companies, we know this kills people, but let's make it look cool so that we can sell more of it. Mm-hmm. I don't think that you're going to find that here.
So the overall approach, not specific, because I know we've talked a little bit about, was it because it was portrayed in a certain video game or certain video games, this company itself and its rifle being used in the game. And then I know Rocco yesterday also, we were having this conversation, and I think to almost the point you were just making, I interpreted a piece of their marketing literature, I guess, different than maybe he did, and that might be part of what's in question. And Rocco, if you don't mind, I don't know if you have that in front of you, but it essentially shows, I think, a male, a soldier, and some fatigues, and the verbiage basically says, become a man again, or whatever it is, get your manhood back.
Consider your man card reissued, I think, is one of the ones.
That's one of the items. Right.
Yeah, exactly. But, if we go after every company that targets young men and wants them to, behave perhaps irresponsibly or encourages some idea of masculinity that is potentially dangerous, we're going to have to take all muscle cars off the market, because they all target young men in a way that encourages, I suppose, or promotes masculinity and perhaps promotes dangerous behavior, like racing a muscle car on the freeway, which could cause and has certainly caused people to be seriously injured or killed. So the slippery slope from what they're arguing here is really, if you don't care about guns, that's fine, but it can affect everything in our lives. So it's something that you need to take very seriously.
Now, Emily, the Connecticut law that the court highlights, I guess, in this argument is the Connecticut Unfair Trade Practices Act, in terms of how they marketed this military-style weapon to civilians. And according to the court, they said the Connecticut law, in quotes, does not permit advertisements that promote or encourage violent criminal behavior. And when I have this image of the Bushmaster firearms, which you might have seen before, and some of the lines on there state, we build each Bushmaster rifle with you in mind. Your purpose is our purpose. We serve in law enforcement and the military. We win 3-gun and high-power long-range shooting events. When you need to perform under pressure, Bushmaster delivers. And then it shows the image of an individual who's out there in, at least the silhouette of someone in military garb with a helmet and their rifle put up in their arm. So according to, and again, Jay was right there, that people can interpret that in a harmless way, and people can interpret that in a way that might suggest for military purposes instead of just civilian use. But the law, again, what it states is, according to the court, the Connecticut law does not permit advertisements that promote or encourage violent criminal behavior. Now, that might go a little bit beyond what you were talking about, just promoting masculinity. they're talking about advertisements that could be interpreted to suggest criminal, violent behavior. And I could see to the point where there is a slippery slope there, where obviously a company could cross a line where they're marketing a product that does say, if you want to go out there and shoot people, this is the gun for you. That obviously, would you agree, would violate the law and under the words that this court outlined?
Absolutely, but we're just simply not there with the advertisements that Remington has put out. All states virtually have this sort of fraudulent trade practices, harmful trade practices. In Texas, we call it Deceptive Trade Practices Act. And really, we're talking about something that just does not fit into this Remington bubble, because the Remington bubble is not, I fraudulently induced you to buy something. I told you to commit a crime with this instrumentality. My instrumentality can only be used for criminal activity. And when we talk about violence, that's really one of the reasons why the gun manufacturers are supposed to be protected from these sorts of lawsuits, because if you are using a firearm, you are using, even if it's a total lawful use, right, there is potential for serious bodily injury or death every time you discharge that weapon. Every time I go to the range, every time I carry my weapon, which is because I live in the great state of Texas, I get to do every day, luckily. But every single day, I know that I am engaging in an activity that could cause someone serious bodily injury or death. And I sure hope that I never have to use my firearm in that way, but it's always possible. So that is one of the reasons why we have to, or they should be shrouded. And I think ultimately there's going to be a higher court who agrees with that.
The issue that strikes me in listening to this is, I think any time you discharge a weapon, you're committing a violent act. Whether you're shooting at a target or an animal, that in a sense is a violent act. And the statute that we're talking about in Connecticut doesn't seem to say incurs violence against people. It just says violence. And I wonder how broadly you could interpret that term violence. But the question I want to ask you, this has struck me, but I want to ask you this: isn't the issue now which law will prevail in a sense? Will the federal law that says you can't sue gun manufacturers when guns are used in a manner that cause injury, which is going to trump the other one? Or is the Connecticut law going to be accepted and say, well, you can apply that and it's not inconsistent with the federal law? As I listen to it, it seems to me that the Connecticut interpretation of their law in this case is inconsistent with the federal law. And if it goes to the U.S. Supreme Court, the U.S. Supreme Court can dismiss the case and say, no, this violates our federal statute. Could you react to that best you can?
Yeah, absolutely. That's the battle that's going to ensue here. And it's one that's, that has to be fought, unfortunately, because, yes, absolutely, we've got a conflict here. It really seems to me like they are trying to shoehorn the Remington Act into this harmful trade practices law, and it does not fit. But assuming that it does in fact fit, yes, there's going to be an argument about which law must prevail. And I do think that ultimately it's a fight that Remington has to fight, because they can't open this door for every other, potential mass shooting or even just active gun violence that could come from one of their products. And then, there is a very good chance that it is something that our Supreme Court looks at. We've got a good composition right now to protect gun manufacturers, so that's a good thing.
Emily Taylor joining us here on the Talk of the Town. She is a Second Amendment expert from U.S. Law Shield out of Texas. She is an independent program attorney with the company there. Mark's got one more, and then we'll let you go there, Emily.
I think it's always important to point out the supremacy clause that said if there is a federal statute and a state statute and they conflict, the federal statute must prevail. And that's what I think one of the things that's an important issue that needs to be looked at in this case.
Emily, full disclosure, Mark's attorney, by the way, as well. So
That's absolutely right. So, I think that it is, again, it's going to be a long fight, but I think that we've got, if I had to pull out my crystal ball right now, I would say that Remington has got the upper hand here.
Mm-hmm. And Emily, just I guess the last point here I'll make, another attorney, Remington's attorney, and their response, going back to one of the first initial points I think you made, with the facts that they had no way of assessing the shooter in this case, Adam Lanza, therefore they were unable to know how he would use the gun. So it might be, and that might be a part of the case because the individual didn't necessarily buy the gun. So I think that you can also make that case that
he wasn't enticed by the ad to buy the gun.
Exactly.
That's the point Emily made.
I think
that's our proximate cause issue here, and it's very strong.
Yeah. Emily, thanks for taking the time again. Great call. I appreciate it.
Thank you.
Got it. Emily Taylor, great job. She's joined us in the past, as I mentioned, from U.S. Law Shield Second Amendment expert.